Hi, I'm Bruce Wells. I'm an associate professor in the Department of Middle Eastern Studies here at UT Austin, and this is Ancient Law Office Hours. The Code of Hammurabi is a big deal because it's our longest, most expansive collection of legal rules and principles that we have from the ancient Middle East. We think it was put together probably around the year 1750 BCE, and it contains over 280 provisions. Some people call them laws, other people aren't sure they actually are laws, so that's a big debate in the field right now. One of the most famous laws in the Code of Hammurabi says that if one man gouges out the eye of another man, then his own eye has to be gouged out. Now, we don't think people were going around gouging out people's eyes, but the law gives us a principle that they tried to follow, at least in that society, and that is the punishment should fit the crime. We have court records where people do assault other people, but usually the punishment is not physical. Usually the punishment is more in the nature of a fine, or some property has to exchange hands to make up for the injury that was caused to the other person. So no, they weren't going around gouging out eyes or cutting off people's hands. Those laws give the principles that the people tried to follow in that particular system. It sure looks as if ancient civilizations borrowed laws from each other. With the famous Code of Hammurabi, some people think it borrowed laws from some previous law codes, such as the laws of Eshnunna, which was a town north of Babylon, and its law code was probably written about 50 years before the Code of Hammurabi. There are even two other older law codes that were written in Sumerian, and some people think the scribes behind the Code of Hammurabi may have borrowed from those as well. One big debate in my field has to do with biblical laws that are supposedly given by Moses to the people of Israel at Mount Sinai. A lot of those laws look similar to what's in the Code of Hammurabi or even in the laws of Eshnunna, and some people have argued that the biblical authors virtually plagiarized their own codes by drawing directly on these other earlier codes from the ancient Middle East. Is that a form of plagiarism? Is it a form of theft? That's a good question, but I think there's a more complex thing going on in the ancient Middle East. Instead of one code borrowing laws from another, I would say they're all drawing on a very similar legal tradition. There's a set of practices and a set of customs that were developed early on in the ancient Middle East, and these customs and traditions spread out across the region in the same manner that writing, which was invented in Mesopotamia, spread out across the whole region of the ancient Middle East. So you have a similar legal culture affecting all of these societies, and you do see some differences. But for example, when it comes to inheritance, the oldest son was usually given a preferential share of the estate. In some cases, he's given a double share, so he gets twice as much as all the other sons. In some cases, he gets 10% more, in some cases 20% more. They all share the basic legal custom that he gets more, but the more minor detail of exactly how much more can differ from region to region. So I think the biblical authors are not necessarily borrowing directly from the Code of Hammurabi or other law codes that came before them. They're drawing upon a whole set of practices and ideas and traditions that were very common throughout the region, and that's the main reason why we end up with codes that have similar principles or rules. One more quick example has to do with an ox that's in the street and gores somebody to death. In the Code of Hammurabi and in the biblical book of Exodus, it says that if the owner has been warned that his ox is a menace and he doesn't do things to protect other people around his ox and it gores someone to death, then the owner himself can be put to death. Again, I think that's the fullest extent of the law, and he probably would have had to pay a penalty or a fine. But in both cases, you have the same basic principle. If the owner has been warned and something happens, then he's in big trouble. And you see the similar things happening with other legal issues where you have the same basic principles showing up in both societies, although there can be differences in the details. So adultery was considered a crime in all the societies that we know about from the ancient Middle East. And in fact, in ancient Egypt and ancient Syria and ancient Israel, adultery is called the great sin. So all these societies considered it not only a crime, but also a wrong that was committed against God or the gods, depending on the society you lived in. Now, they defined adultery a little bit differently from how we do. So for them, when they talk about adultery, The key is that a married woman is having sex with a man other than her husband. So the man might be single, the man might be married. It didn't matter. What mattered was whether or not the woman was married. So this meant that in some cases, a married man could have sex with women other than his wife as long as those women were not married. So if he were to have sex with a sex worker, then they would not consider that adultery. If he were to have sex with the single unmarried daughter of his neighbor, that was not considered adultery. He might have to pay his neighbor a bride price and then marry that daughter, but he wouldn't be subject to any kind of severe penalty that normal adultery was subject to. Now, why was it punished so severely? That's a great question, and we're not exactly sure. Partly because they considered it a sin against the gods, made it a very serious wrong, but they also considered it to be a violation of another man's rights. He has rights to his wife. You've invaded, I think they would say, some sacred area of his privacy, and because you've threatened him in this way, you had to be punished. And so many of the law codes we have say that if you commit adultery, whether you're the man or the woman involved in it, you can be subject to the death penalty. But again, we don't have any records saying people were actually killed for adultery. Normally, the man would divorce his wife if she committed adultery, and oftentimes the male lover involved would have to pay to the man a lot of money because he had violated this man's rights. Scholars disagree about this question. Did the Israelites treat these laws in the first few books of the Bible as codified law or as something else? So there are basically three views that scholars will support. One view says, yes, the Israelites treated them as codified law. In fact, there's a story in 2 Kings chapter 14, I think it is, that says a king did not put to death the sons of a couple of assassins who had killed an earlier king, because he didn't want to violate the law that said you shouldn't kill the children for the crimes committed by their parents. And that law comes right out of Deuteronomy chapter 24, verse 16. So there seems to be a story that says this Israelite king was following the rules that had been laid down in an earlier book of the Bible. But there are other views that scholars support. So the second view would say they didn't really treat the laws as codified law. They treated them as important principles that should govern the legal system as a whole, and you had to abide more by the spirit of the law than necessarily the letter of the law. In fact, this view would say the laws in those first few books of the Bible are not necessarily prescriptive rules, they're more descriptive of the kinds of rules that were generally followed in ancient Israel. The third view says these were not laws at all. They weren't prescriptive statutes or rules, they weren't descriptive of what the society normally did. They were more like just wise advice that you could follow or not, depending on what you felt like. They would say then that this wise advice grew and was expanded upon, and in later times, eventually came to be treated as law. But initially, when the laws were written down, they weren't meant to be laws as such. They were just meant to be, as I said, a set of propositions for how you might want to live your life or conduct your affairs in society, but you didn't necessarily have to follow them. It was only later, close to the time of Jesus or so, when the Jewish community started to treat these things as actual law. Now, my own position is that these rules are descriptive of the kinds of practices and customs they would normally implement in their legal system. They also embodied certain principles that they believed their legal system should follow. So if you're confronted with a case that might not lend itself to having you follow the letter of the law, that was okay. You could still follow the spirit of the law. Let me give you one quick example. In a couple different places in Deuteronomy and in the book of Numbers, it says you shouldn't convict someone of a serious crime, especially homicide, without two witnesses who would be testifying against the defendant. But in some cases, you might have plenty of evidence that shows a person stole something or even committed murder, but you've only got, let's say, one witness, but lots of other types of evidence. In the case of theft, maybe physical evidence was found in the hands of the person who stole the goods. I think the spirit of the rule would say, you're certainly welcome to convict this person based on one witness plus the other evidence you have. It's not as if you can have a boatload of evidence, but if you don't have two witnesses, you can't convict the person. the system wouldn't have been able to function in that way, in my opinion. So I think initially, these provisions that we find in the first few books of the Bible tell us a lot about how they conducted themselves legally, but they also impart to the readers certain principles and guidelines that they wanted them to follow as they operated within the society and as they tried to conduct their legal affairs. Yes, the ancient Middle East had forms of civil law. Now, it's not exactly the same as we would think about it today. I would say in the ancient Middle East, they had three general categories of law. The first would be wrongs against the king or the gods, and those were the most serious and carried the most serious penalties. The second might fit our category of criminal law, and this would be serious wrongs against another citizen. So this would include murder or theft or adultery, or false accusation in court, which could be a dangerous thing to do. Then there was a third category that had to do with more minor wrongs. And this would kind of fit our category of civil law, but this would be when you didn't pay the full price for something you purchased, you didn't repay a loan on time, you divorced your spouse without a good reason, adoption contracts or other types of contracts that went wrong somehow. These would fall into the category of civil law, but they still might go to the same officials that they might go to in the case of a more serious criminal issue. So in the case of divorce, for example, a man could divorce his wife for just any reason he wanted to, but if he didn't have a good reason, he had to pay her a substantial financial settlement before he sent her away. If he had a good reason, then he could send her away without paying a financial settlement. And sometimes these cases had to go to a judge to determine whether or not he actually had a good reason to divorce his wife. If someone didn't repay a loan on time, there were various measures that could be taken to deal with that. But sometimes they had to go to a judge to decide if the person had or had not paid their loan on time, and was there documentation or were there witnesses who could verify one story or the other. So in those cases, I would say they do compare fairly well to what we would call civil law. With these cases that I'm calling civil law, the more minor harms that might be committed, the penalties were usually financial in nature. With the more serious harms, the penalties would still end up being financial, but you were always under the threat of some kind of physical penalty being imposed. So if you steal someone else's goods, in theory, they could cut your hand off, but really what that does, that punishment hanging over your head, it puts you in a very bad negotiating position. So as you begin to negotiate for the fine that you'll have to end up paying, the person you're negotiating with can always say, I don't like what you're offering, let's go back to the physical punishment of cutting off your hand. And then you might say, okay, I give in, I'll pay the higher fine, the greater compensation to make up for the theft that I committed. Now, could you sue a king or a pharaoh or some high official for treating you badly? You might be able to sue a high official by appealing to the king if you could get the king's attention or get a friend to get the king's attention for you. But to sue the king was basically unheard of in that time. The king made the law, the king was the law. The king really only had to answer to the gods. Trials by ordeal actually did take place in the ancient Middle East. We know them best from Babylonia, which would be southern Mesopotamia, and Assyria, which would be northern Mesopotamia. We think they occurred in both places. The one ordeal that we know of best is what we call the river ordeal. So someone might be on trial for a serious wrong of some kind, and the judges might not be sure whether the defendant is innocent or guilty. So in that case, they might do a number of things, but one of the things they could do was to ask the defendant to undergo the river ordeal. They would take the defendant down to the edge of a river. If there was a famous river close by, like the river Euphrates, they would take the defendant there. And they would have the defendant enter the water. If the defendant were to sink into the water, that would be a sign of guilt. If the defendant were to float, it seems to be that that would be a sign of innocence. But is that all there was to it? It seems to be the case that the defendant had to make it across the river, or at least to a certain point in the river, before sinking. And it's possible they had to actually carry a weight or a stone with them to make it harder. Now, some scholars have said, well, if they're guilty, they're going to sink and die. They'll drown. But that doesn't seem to be how the river ordeal operated. If you couldn't make it across and you started to sink, they would deem you guilty, but then they would haul you out of the water and punish you in some other way. So we know of cases where someone didn't pass the river ordeal. They were gotten out of the river alive, and then they had to turn over a certain amount of property, in some cases all the land they owed, but they didn't lose their life in the river ordeal. There's another text that's a literary text that describes a river ordeal, and it says the person sank, so they must have been guilty, but then they don't reappear again. No one knows what happened to them. A little bit later, that same day, they find the body downriver, washed ashore. And when they examine the body in this story, it's not dead from drowning, it was dead from being burned. Now, how do you end up being burned in a river? The story says that the person sank and the river god put them to death through burning, not through drowning. So in a sense, it's a kind of supernatural death that they believed the person experienced. Apart from the river ordeal, we're not sure if there were other ordeals like walking on hot coals or something, but there may have been some kind of drinking ordeal. There are some texts from Mesopotamia that suggest this, but they're not entirely clear. There is a text in the Bible, though, in the book of Numbers, where there seems to be a drinking ordeal. If a husband suspects his wife of adultery, but he's not sure if she committed it, and he doesn't have any good evidence, he can bring her to the priest of their shrine, and the priest will write down an oath, and the oath will say something like, "If I have committed adultery, may I be punished." He writes those words down on something, we don't know exactly on what. And then the text says he'll scrape those words off into a cup of water. And then he also adds to the water some dust from the floor of the shrine. He mixes all this together and he has the woman drink the water. She drinks the water and she also has to listen to the priest recite the oath, again, which says, "If I committed adultery, may I be punished." And then she has to say the Hebrew word amen, which comes over into English eventually as the word amen or amen, which means, may this be the case. So if I have committed adultery, she's giving assent to having herself punished. Some people don't think it's a drinking ordeal as such. It may just be an oath ritual. But she does have to drink this rather odd potion, and it says that her abdomen will swell and she will not be able to give birth if she's guilty. She may become infertile. If she's innocent, it says she'll be fine and she'll be able to give birth in a normal way. So this could be our one example of a drinking ritual that may confirm some of the other texts from elsewhere in the ancient Middle East that suggest there may have been drinking rituals there as well. Yes, contracts definitely existed in the ancient Near East. Now, some scholars don't want to define them as a contract the way we might define it today, but I think we can say they were definite contracts because two parties would be involved and each party would give up something for the benefit of the other and expect to get something of benefit in return. And in my mind, that definitely counts as a contract. They were used for all sorts of things. They could be used for loans, so the debtor would give assent to a written contract that would say he was receiving X amount of goods or silver from the lender and he would have to repay it by a certain date, usually at a certain interest rate. 20% was a common rate, even 33% could be an interest rate. These weren't annual interest rates, these were just total interest rates, meaning he would have to pay back the principal plus 1/5 or 1/3, depending on what was decided. Contracts were also used for marriage agreements. Two families would enter an agreement saying, "Our son will marry your daughter," and vice versa, and they would agree on financial terms as well, because the groom's family would have to pay a certain amount of money to the bride's family, and the bride's family would have to provide their daughter with a dowry, and these were often agreed upon ahead of time. Contracts could also be used between nations or between kings, and we would call these treaties, but they were based on the form of a contract, and each king would agree to certain terms, and they would have to be obligated to perform certain actions for the other king, and hope to get a certain benefit in return. Contracts were used for other things as well. One person could rent out equipment that they had or even slaves that they owned to another person, and the terms for these agreements would be collected together into a contract. People would give assent to these contracts usually before witnesses, but we have written contracts as well, and sometimes they would make a mark on the contract. They might place their personal seal on the contract. The contracts would be recorded oftentimes on wet clay, and the person could then impress their seal onto the clay. Sometimes they would actually just make a mark with their fingernail. And we have a number of clay tablets that just have fingernail marks on them. You might say, well, how can you tell one person's fingernail mark from another person's? And basically you can't, but you would have names of witnesses recorded on the contract, and you would bring these witnesses to court if there was a dispute, and they would say yes or no as to whether or not the parties both agreed to the contract and made their mark with their fingernail on the contract. In some cases, you have slave contracts, and these would often involve debt slaves. So if a husband or a head of household, a father, couldn't pay his debt back on time, he might have to turn over one of his children to the creditor as a debt slave. And the terms for this would be recorded in a contract. And in some cases, only a handful, we have the footprint of the child impressed onto the clay as a way to say even this very young child was giving their assent to the terms of this debt slavery contract. So they used contracts for all sorts of things, from marriages to adoptions to sales to rentals, even to international contracts that we call treaties. And this form of making agreements permeated, it seems like, all of society, and people were generally familiar with this idea. Religion was really intertwined with everything in the ancient Middle East. It was intertwined with family life, with politics, and certainly with law. The king had a mandate from the gods to establish justice in his land. The idea was that the gods would give the king wisdom, and then it was up to the king to issue good rules, good laws, and good judgments when he ruled on disputes. Now, we don't know to what extent the king actually did these things, but it was certainly part of the rhetoric to say that the king was involved in doing what the gods wanted him to do, and that meant caring for the poor and helpless and trying to make sure justice was being practiced in his society. That was part of how religion influenced the law. We also see religion showing up in the Bible, of course, because you have laws that are said to have been given by the God himself. That's different from what we see in other parts of the ancient Middle East, where the king is the lawgiver and not the god or the gods. So religion was important for lawgiving. It certainly was important for legitimizing the rules. People believed that within their kingdom, their king was supposed to be a just king, as I said, but they also believed that society was supposed to be ordered according to what the gods wanted. So they believed that their societies followed divine order. They had to sort of trust their king to be doing this and making sure this was happening. But they believed that outside of their realms, chaos reigned, and you didn't want to be caught outside the realm without some protection, because the people out there and in other societies were probably not following the kind of divine order that you believed your society was following. So yes, the gods, belief in the gods and belief in the idea that the gods had a will or a plan for society was important to justify not only the king's reign, but also the king's rules and how he wanted society to be ordered and to operate. When it comes to biblical texts and biblical rules, yes, they believe that the rules were given by the God, but there is some tension between two different perspectives that show up in the Bible. One perspective says you have to do whatever the God says simply because the God says it. The other perspective says our God gives us laws that are good because he wants us to operate in a way that is consistent with goodness and what is right and with justice. And our laws are so good that other nations will look at us and they'll be able to recognize, by exercising their reason, that our laws are better than theirs because ours are more aligned with what is good and what is just and what is right. So the question almost sounds like what Plato talks about when he talks about what we call Euthyphro's dilemma. Is the good good because the gods say so, or do the gods say certain things because those things are good? Can you use human reason to discern what is good, or do you just have to wait until the God tells you what is good? And so it seems to be the case that people in ancient Israel were trying to think about this important philosophical question, and we deal with it some today. Is there some kind of higher standard, some kind of morality that we should be trying to align ourselves with? Or should we just try to figure out what works the best for our society and create laws in line with that? So I think what you find in the ancient Middle East is, yes, religion is used to try to legitimize the powers that be and the laws that they are saying everyone has to follow. But there's also this idea that there is a kind of goodness, a kind of rightness that exists on its own. And part of what society should be doing is trying to figure out what that goodness and rightness is and trying to order their society in line with that. I think the civilization where I would least want to be caught breaking a law would be the Assyrian civilization. We divide Assyrian history into a couple different periods: the Old Assyrian period, the Middle Assyrian period, and the Neo-Assyrian period. We have a collection of laws from what we call the Middle Assyrian period, roughly around 1200 BCE or so. These laws have some very harsh punishments. Now, a lot of them are similar to ones you might hear from elsewhere, like an eye for an eye, a tooth for a tooth. That expression shows up in the Bible as well. But these laws make it sound as if they were really going to do this to you. When you move into the Neo-Assyrian period, they talk a big game, and they talk about how they would punish criminals sometimes by impaling them on stakes or treating their prisoners of war very harshly, cutting off body parts, piling them up, torturing them, and so on. We think they would bring visiting emissaries from other countries into a certain hall and make them wait in this hall before they could go in and see the king or another Assyrian official. And in this hall, they would have carvings and reliefs of scenes from their battles where they are doing these very violent things to their enemies, again, cutting off body parts and killing them in very gruesome ways. We think the point was to scare the emissary from the foreign nation and prepare him emotionally and mentally for giving in to the Assyrian king or other high official when he met with them. Now, we don't know if the Assyrians were as brutal as they claim to be. They remind me of the character in the movie The Princess Bride, whose name I think was something like the Dread Pirate Roberts. This pirate had a reputation for never taking any prisoners and killing everyone he captured. He had a reputation for being brutal and violent and not providing any mercy to anyone. But as we find out in the movie, it was just all talk, and that he could actually be kind and beneficent to people he captured. So with the Assyrians, they have a terrible reputation, and this comes through even in the Bible. They're talked about as a violent and brutal group of people. But I think it may have been a reputation they wanted to cultivate to scare their enemies into being more generous with them when they negotiated with them. And they probably practiced their laws and enforcement and their rules in the same way as other societies. But I wouldn't want to take a chance. So if I'm back in the ancient Middle East, the one place I don't want to get caught breaking a law would be in Assyria. No, you do not have my permission to do that. Let's take the last thing first. In the Code of Hammurabi, it says that if a builder builds a house and it turns out to be faulty and collapses and kills the son in the family who's living in the house, what actually is supposed to happen is the eldest son of the builder is supposed to be put to death, not the builder himself. The idea is that whatever wrong happens to your household is supposed to be turned around and inflicted on the builder's household. Now, again, I don't think they would have necessarily killed the builder's son, but that would have put him in a very difficult negotiating position, and he probably would have been willing to pay whatever the victim's family demanded. When it comes to the false weights and measures and the goat, there's going to be some kind of serious financial compensation you can seek from your neighbor. By the way, why are you still living next to this person? Move away. But with the goat, if you could find your goat is still alive and can be returned to you, then he would have to return to you your goat plus one other goat. If he had killed the goat or sold it off and you couldn't get it back, several legal systems that we know about would have said he has to give you back 4 goats, not just 2 goats, because yours is gone forever now. And with the false weights and measures, if he defrauded you out of a certain amount of money or goods, he would have to pay you back at least twice what he defrauded you, maybe more depending on the system you're living in. But no, you do not have my permission to stone him.